Good afternoon. My name is Paul DeBold, and I'm the chair of Venable's Government Contracts Group. I wanted to welcome everybody to the second of our four-part bid protest series. Today's topic is bid protest, winning strategies and themes. Joining me on today's panel are my colleagues, James Boland and Kristen Nunez. I was going to take the opportunity to give them, to let them introduce themselves.
Hey, good afternoon, everyone. I'm James Boland. I'm a partner at Venable's Government Contracts Group, and I'm excited that you all joined this afternoon. My practice is largely in the claims and disputes and bid protest areas. So have been litigating bid protests for a number of years, and excited to talk about them.
Hi, everyone. My name is Kristen Nunez. I'm a fourth-year associate here in Venable's DC office. And I joined Venable recently from a clerkship at the Court of Federal Claims. So I'm really excited to get to share with you all some insight and interesting things that we have all learned. James also clerked at the court throughout the process today. And thank you all for joining.
Great. Well, thank you both for being on the panel today. I also, before we get started, I also want to remind everybody that we'll be having our third webinar next week in the bid protest series. It relates to key personnel. It'll be on Thursday, June 17th, and it'll run from 12 to 1:30. And then the last webinar in our series, which relates to organizational conflict of interest issues, will be held on June 24th. And it goes from 12 to 1:30 as well. Krista, can we go to the next slide, please? So our agenda today is pretty straightforward. We've really broken the presentation into three parts. First, we're going to discuss whether to protest and forum selection. Second, the panel will discuss whether a company should intervene in a protest. And lastly, we'll discuss successful arguments and themes that we've seen over the years that have arisen in bid protests. Go to the next slide, please. So the first issue we're going to discuss is whether or not your company should protest at all. Frequently we talk as many companies into not protesting as we do into protesting. So there are a lot of things that your company needs to consider in making that decision. The two types of protests we're going to cover are a pre-award protest and a post-award protest. So if we go to the next slide, we'll just talk about a pre-award protest. So let's talk about those first. I mean, typically, when clients come to us and indicate that there's a problem with a solicitation, it's not our recommendation to file a pre-award protest right out of the gate. Based on our experience and what we've seen over the years, we think it's more effective to get involved early in the requirements definition. It's helpful to submit questions prior to the time and date our proposals are due. If there's not an opportunity to submit questions to the agency about the solicitation, you can write a letter or an email that highlights your concerns about some aspect of the solicitation. And if all else fails, you do have the opportunity in your proposal to sort of clarify your understanding of the various terms. The other thing is that you really need to avail yourself of the opportunity to attend industry days and make sure that you ask questions so that you have an understanding of the procurement. Now, if after taking those steps and being proactive, there's still a solicitation defect that could impact your company receiving a contract award, then maybe you should consider filing a pre-award protest. Based on what we see, the vast majority of pre-award protests focus on a term of the solicitation. It's either patently ambiguous or it conflicts with another term of the solicitation. There's some concerns with the evaluation criteria or a requirement, a specification in the solicitation that may tilt the competitive landscape toward a competitor. The timing for pre-award protests is generally they have to be filed prior to the due date for a proposal. So it's important that you keep in mind the various time zones, because if your command is in Central Time Zone, their time may be 3:30, it could be 4:30 your time, so you need to pay attention to that issue. After a pre-award protest is filed, with very limited exceptions, the agency can't award the contract until after the matter is resolved. And while it's not required that you you submit a proposal before filing the protest, I think that our recommendation would generally be that you do submit a proposal that sort of outlines what your understanding is, so that you don't inadvertently walk into an argument that your opportunity for award has not been prejudiced. So having talked a little bit and setting the stage for pre-award protest, Chris is now going to talk about deciding whether to file a post-award protest.
Hi, everyone. So one of the first things in sort of figuring out whether or not you want to file a post-award protest that we recommend is first, did you receive a debriefing? I don't know if some of you were able to attend the webinar last week. If you weren't, there is a recording of that, during which James discussed in a lot greater detail than I'll go into the process of debriefing. And for those of you who are GSA Federal Supply Schedule contractors, that would be called a brief explanation of award, which includes just a little bit less information. Those documents can be really, really helpful to attorneys as we go through this process. It's also really great for the contractor to have an idea of maybe what they could do better next time, or, potential grounds of protest, which is the subject of today, of course. So one of the important things that we want to remind everyone about is to not forget the timing requirements. So in the pre-award context, you want to think about it when you're eliminated from the competitive range. And then in post-award, you need to request that debriefing within 3 days. Interestingly, there has been some more case law recently on enhanced debriefings in the SECAS day. And so now knowing how the Federal Circuit interprets some of those requirements, timing is especially critical. And so James will discuss more of the nuances of the SECAS day in particular a little bit later on, but I want to highlight a timing component of all of this. So in terms of the GAO, you have to file your protest within 5 days of the offered debriefing date in order to get to trigger the automatic SECAS stay. And then in terms of the enhanced debriefing at the Federal Circuit, a disappointed offeror is entitled to submit follow-up questions within 2 business days after receiving the post-award debriefing. That's what you would do if you want to kind of extend it to that 7-day time period. And so this gives you a little bit more time. And so we pretty much say always, to the extent that you can, you should immediately request your debriefing and get this process started. And then you can always, that way you're also especially able to extend the SECAS stay 5 days. One of the most recent decisions that we have that clarified and confirmed what many of you might know is that if you don't ask follow-up questions during the enhanced debriefing process, then you still have that 5-day clock to have the automatic SECAS stay triggered. And so it's really important that you do ask those follow-up questions, even if it's just one. It seems to be that that's what the Federal Circuit says is enough to get those 2 extra days. And because that's kind of one of the strategies in protesting at GAO versus the court, because the court does not have that automatic SECAS stay. And so before I talk about some of the preliminary considerations of whether to file a protest, I want to briefly go through some of the post-award debriefing process to highlight some of the facts that you would get that will help in formulating those post-award protest grounds. So in accordance with the FAR, in the post-award debriefings, you'll receive information on a general perspective. You'll get a summary of the rationale for award. You'll also get reasonable responses to relevant questions about whether the agency followed the source selection procedures contained in the solicitation, applicable regulations, other applicable authorities, and whether or not those were followed. So those can be some key points for more objective protest grounds. And then in terms of the debriefed offeror, whether you're the awardee or not, you'll get an evaluation of the significant weaknesses or deficiencies. Of course, that's usually something that you really want to know, particularly if it is a deficiency, because that could be on its own a protest ground. You'll also get information on your past performance evaluation and general information. And then for the awardee and the debriefed offeror, you'll get the overall evaluated cost or price, including those unit prices, and a technical rating if applicable. And so that information, particularly the pricing, and we will get more into this, can be really good for perspective to see sort of where you're at against your competitors. So both from a practical business standpoint and then from the protest standpoint, it's really helpful to have that information from the price because it can speak to different issues later on in the protest and give you a better idea if it would be worthwhile to file that post-award protest. And then last, with respect to all offerors, you'll get an overall ranking of everyone when the ranking was developed. And then for acquisitions of commercial items, the make and model of the item to be delivered by the successful offeror. So those are from FAR Part 15. And so, sometimes there will be variations. Some agencies we've seen, will go into a lot more detail in a debriefing than they might not otherwise. And so it kind of just depends on what you get, but any of this information can be helpful because it will provide us with information in order to be able to figure out kind of what we can run with. So some of the preliminary considerations, the differences in ratings and price, consider how many factors you need to win to become the best value. So for example, if you received ratings that are much lower across the board on every single factor and your price is higher, I can't say that that would be you probably wouldn't have a high likelihood of success in that post-award protest context. That said, if some of the ratings are closer and the prices aren't that far apart, that's probably worthwhile because if you have these different data points, you're able to look at different perspectives, and if you're able to prove enough of them, then you can win. But if you have to win on every single factor and your price is higher, the odds that you're going to win are just pretty slim because it's requiring that the court or the GAO or wherever you're protesting look at so many different factors. And so it creates almost this domino effect. And it kind of gets to the point of sometimes it's like, so you have to win this and then that in order to get the award. And given the standards that there are, it's probably not worthwhile if you have to go through so many steps in order to win. So one of the other important considerations is standing, and we'll get into the details of standing and prejudice. I would say that from everything that I've looked at in my experience, that the Court of Federal Claims more loosely applies the standards than the GAO. There's the preponderance of the evidence standard, and a prejudice determination for the purposes of evaluating standing is a limited review that seeks minimum requisite evidence necessary for a plaintiff to demonstrate prejudice and therefore standing. And so at the court, in order to establish that, you also have to show that you're an actual or prospective bidder and that you had a direct economic interest in the procurement or proposed procurement. And so in looking at that, one of the first questions that the court will ask is, okay, are you an actual or prospective bidder? Usually that's a pretty straightforward analysis, and that's not usually contested too much. The question can sometimes turn a lot more on whether or not there's a direct economic interest in the proposed procurement, in the actual or proposed procurement. So sometimes, and you'll look and see at the court, there's a lot more case law on that very topic, just because it can kind of go either way. But at the end of the day, if you don't have standing, then at the GAO or at the court, your case is going to be dismissed. And so it is really important to kind of assess all that. And in drafting a post-award protest, if you're the protester, one of the things that we're going to discuss sort of throughout as we go through the different themes is the glass house scenario, which is essentially, in order to establish standing on these various things and when you're making your arguments to kind of try to prove, all the different factors and that the best valuation was flawed, you always want to make sure that whatever arguments that you're making are not ones that your own proposal doesn't meet, right? Or say that you might have been late on something or you didn't follow exactly. I mean, I've worked on protests where, in fact, I've seen that the agency said, all the offerors didn't comply with this page or numbering or formatting requirement, like the cover page of the proposal didn't include this, but we don't really care. So there will be that sometimes, but if you know that the agency might not have caught something that is actually going to be problematic for your proposal, you don't really want to make those arguments. And so those are things that attorneys are always cognizant of as we kind of go through these things and strategize as to how we want to pick the protest grounds that we'll proceed with. And so another thing, and I'll talk about this a little bit more later, but if your proposal is non-compliant with respect to one of the issues and the GAO and the court have sustained protests on these grounds, you don't have standing. So if your proposal is not compliant, you probably don't want to be filing a protest if you somehow still manage to get the award. It might be worthwhile to intervene in that situation. And again, we'll talk about that a little bit more. But otherwise, in terms of the GAO standard for this preliminary consideration is just the GAO will not sustain a protest unless the protester demonstrates a reasonable possibility that it was prejudiced by the agency's actions. So basically, it's a substantial chance test. And so one of the next questions is, can you demonstrate prejudice? And I think this is a little bit more nuanced than a lot of people think, especially at the court. So GAO, it's relatively straightforward. In the post-award context, it's unless the protester demonstrates that, but for the agency's actions, would have had a substantial chance of receiving the award. In the pre-award context, it's where none is shown or otherwise evident, they won't sustain a protest, even if you could show that the agency's actions were improper. But competitive prejudice at the end of the day is always required. So you have to demonstrate in your initial protest, how exactly were you prejudiced by the agency's actions? For example, if you protest the technical evaluation, there could be a situation where you're correct in making your arguments, but simply because you won on that doesn't mean that you were prejudiced, because you could have had horrible ratings and everything else. Or maybe that you were non-compliant with something else or received a rating that disqualified you from award. So you could win on a protest ground for the technical evaluation, but you could still be kicked on this if your proposal at the end of the day, one of the ratings that disqualified you is upheld. So that's just something to kind of keep in mind. And in deciding whether or not you want to file a post-award protest is how many hurdles do you have to overcome? And it's questions like these that are, how many steps is it that you have to win?
Hey, Chris, I was going to jump in and just make a comment there. One thing that struck me is, as folks are evaluating whether they can demonstrate prejudice, sometimes, the debriefing or the brief explanation does not give you much information at all. And you really don't know whether, you really can't size up whether there's been prejudice because you don't know much about the awardee's ratings and you're sort of left to guess. And something that we oftentimes will do, and I think is familiar to anyone who's filed protests before, is you can file a protest and you can always withdraw at some point. If the government is not giving you that information, you can put together those arguments and see what's there, and hopefully, if you get a record, you may find out, for example, that it takes a protest to get the information that you should have received in a debriefing. And if that information is telling you the same information that you would have assessed earlier on, you can simply withdraw the protest.
Yeah, I definitely agree, James, with that. I think that's a smart approach to try to get more information, both in the protest and then, of course, for your business perspective.
Yeah, I think another problem with competitive prejudice can be where maybe you can identify errors in the technical or management or past performance evaluation, but you're unable to show how you could have made your price more competitive. I mean, James and I had a protest a few years ago where the GAO essentially said, yeah, you know what, you're right. The agency wasn't perfect in their evaluation, but you're still $150 million higher on your price, and you haven't been able to show how you'd be able to get your proposal competitive. So you need to think about that. The other point on the debriefing, I was looking at a case this week. Sometimes before you get your formal debriefing, the government will send you like a preliminary analysis or preliminary discussion of why you didn't receive a contract. And you need to look at that pretty carefully, because there was a case that came out from the GAO within the past couple of weeks where the basis for the protest was actually in the initial description that they received. The company didn't get anything out of the debriefing relating to that ground. And the GAO was of the view that a protest based on that initial documentation, it was filed as part of the later protest, was untimely. So to the extent you have communications with the government, you get information from the government, you need to scrutinize it pretty closely and then think about, whether you need to move forward with the protest. As, we always talk amongst ourselves, if the GAO says we're early, great, I can redo early. None of us can undo late. And so, it'd always be better to be more aggressive and maybe a little premature than to be late, because the timelines for filing at the GAO are very, very restrictive.
Thanks, Paul. So in terms of, in just finishing up this prejudice discussion, I think it's important to highlight here, because I did notice this a lot over the past few years at the court. There's actually 3 different areas of prejudice at the Court of Federal Claims. So the first, and this is when you file your complaint, is whether or not you're able to establish prejudice in terms of standing. And then the other 2 are in the post-award context, and I'll go through those in a second. But in terms of the first prejudice showing for standing, the court must analyze prejudice for purposes of standing before it decides the merits. And so in that instance, standing at the onset is more properly construed as a question of potential rather than actual prejudice and assessed based on the cumulative impact, basically, of what's included in your complaint, which the court will assume as true. So I think in many respects, it's almost easier to get into the court first, which will in turn produce the full record. If you're able to meet those minimal standing requirements, I do think that they're pretty low. Where it can become more of an issue is in the post-award context of getting to the actual merits. And that is a prejudice. You have to, in the first instance, you have to show an error and that you were prejudiced by that error. That's the general standard. But in terms of the differences between how you show prejudice at the court, the first bucket is basically when an irrational or arbitrary and capricious agency action has occurred, prejudice is presumed. And I think that's pretty critical. And so if you're able to show, for example, that the technical evaluation was unfair, that the past performance evaluation was unfair, then prejudice is automatically presumed. And I think that that is not emphasized as much as it should be and could be in just different protests. And I have truly noticed that a lot because in the other instance, and this is going to be sort of the objective versus subjective protest grounds that we'll get a little bit more into detail on, is that when a violation of a statute or a regulation has occurred, you actually have to show a separate showing of prejudice as to why the violation of that statute or regulation prejudiced you. And sometimes that can be a little bit tricky on the one hand, but on the other hand, it's also that, okay, if you're able to show that there was a violation of this, for example, say that the agency did not conduct a price evaluation in accordance with the requirements of the FAR as included in the solicitation, well, you have to show prejudice there, right? Because you're saying you didn't do it in accordance with the solicitation as required by the FAR. This part of the FAR you didn't meet. If you're able to show, look, if there were all these differences in prices here, it would have shown, for example, unbalanced pricing or something else like that had they done it. I'm prejudiced because they would have, evaluated the awardee's price at a much higher level than what they ended up doing. And so I'm prejudiced because then I would have been next in line for award and I would have gotten it because there are these issues with their price proposal. So I think the distinction between those two different ways in which you have to prove prejudice and show that is really important. And I actually think that that's not teased out as much as it could be in terms of protests that are filed at the court. And this is sort of to just wrap up everything that I've been talking about in coming up with the assessment of possible arguments. There's three main things. First, how was the evaluation with respect to your actual proposal? Are there issues there? Again, this is important to look at the glass house concept. Are you asking counsel to make arguments that you might have problems with your own proposal? Or do you know for a fact, someone else doesn't propose a solution like that? They're the incumbent. You've been doing similar work with them. You know that that's not possible. And so that's kind of important to also keep in mind when you're selecting what arguments you want to make and what's a viable ground, because if it's going to ultimately hurt you in the end, it might not be worth it. So one of the second things is just what are the evaluation issues regarding the awardee's eligibility or its proposal? Some of the things that we'll see in this context, and we'll go into more detail are, was the awardee able to meet the clearance requirements? What are the exact dates? Do you have to have all of your contractor employees have the clearances within 30 days or 60 days, or does it have to be the date of performance? And so there's sort of a fine line sometimes between contract administration and these issues, but always looking at those kind of requirements of the solicitation are really important. Other arguments that we will talk about are sort of on the NAICS code or the DUNS number. Are there issues with respect to that? Do you know about an issue that the awardee has? You know a lot about their business. You know where they're located. You check the NAICS code. You're like, why does this not match? Well, that could be a viable protest ground. Some of the other things are technical and past performance. Oftentimes, if you've worked with that contractor, you're familiar with them, it's really helpful to provide attorneys with that information because it gives us more context as to sort of the technical components, but also the broader context of what the GAO and the agency might be looking at as they go through these processes. And then other things, so other sources of information to file a protest, it's really helpful to look at articles. We can run searches of the types of awards that the person, that the awardee has received and kind of see, do they even have experience in this field? Does the client know if they have experience in this field? That might be worth looking into, especially depending on how the solicitation was written. Other things are, experience working with a contractor, like I've said, what's your personal knowledge of what they have done during performance? And then this can sometimes be a little bit more of a tricky argument, but it's certainly something that we look at and really appreciate when we're given this information is, have you seen job postings on the websites of the awardee. And again, this can also kind of dance along the fine line of, is it a contract administration issue, or is this actually a post-award protest ground that can prevail? It's still really helpful to have an idea of that, especially if it kind of overlaps with clearances, which I've personally seen a decent number of arguments on. And so these are kind of the general things that you want to think about as you're assessing those possible protest grounds.
Yeah, Krista makes a good point that, there's a lot of sleuthing that you can do as a company regarding your competition. To the extent that this is a relatively large procurement, you can research and find whether the offeror has had experience with programs of this size, scope, and complexity. As Krista mentioned, you can look at their job sites to see if some of the key personnel positions are still open, and is that going to give you an opening to file something about key personnel claims. An area that can be a little tricky, and it's come back in a couple areas, it deals with cage codes and DUNS numbers, and whether the entity that submitted the proposal, is it relying on past performance or corporate experience from another corporate entity that has a different cage code or DUNS number, but they haven't shown in their proposal that it's actually going to do the work. So, for example, if you know that a company filed a proposal, but they're really going to do the work out of another office, that may be something that's helpful for us to know as you're looking through the various proposals, looking for various protest grounds. But there is a lot of sleuthing that you can do on the internet to really assist your outside counsel in, putting together viable protest grounds. James, I think you're going to talk about choice of forum.
Yeah, thanks, Paul, and thanks, Krista. So, okay, so you've heard, from Krista, just sort of the, some of the things that you really should be thinking about when you decide whether to protest, and then sort of sequentially here, the next decision that you need to make is where, what forum will you choose to pursue your protest in. And there are a few options, but there are really three main options. There's the agency, there's the Government Accountability Office, the GAO, or the Court of Federal Claims. And I'm going to discuss the agency level protest in the GAO now, and then I think Krista's going to talk about the court as an option. So let's begin by talking about an agency level protest. It's a less formal protest that is submitted to the contracting officer only. It's a letter. It looks like a formal protest, or and it's not that it's you take it less seriously, but it tends to be a shorter letter that's submitted to the contracting officer objecting to an issue, whether it's a pre-award or post-award concern. You will find that agency level protests typically make the most sense in a pre-award context when you have some issue or concern with the solicitation, and you're more likely to get a response, a favorable response from the contracting officer, if you are using your agency level protest to point out what's really a clear error, a mistake. If you think about your typical post-award environment, for example, when the government has made a best value decision after an extensive evaluation of proposals, the odds of a contracting officer changing his or her mind simply because you send a letter saying you disagree are very low. They're almost never going to do that. If they've made the decision after an evaluation, they're going to stick to it unless someone tells them it was wrong. And so I think for that reason, we usually shy away from agency level protests in most post-award contexts. They make sense when, for example, a solicitation has an ambiguity. If something is just not clear or can be interpreted two different ways, that's a classic issue that you ought to resolve before you submit your proposal, and it's probably not worth making a big deal out of it, going to the GAO or the court over something that the agency may just correct on their own. If you point it out, that may do it. In most of these issues, I would also attempt to resolve it informally first. I mean, through the Q&A process, that's typically done first. But if that's unsuccessful and there's some issue or defect in the solicitation, like an omission of a clause that you think is important, that's something that you would then want to push a little harder. And short of going to GAO, you can send a letter to the contracting officer. Paul, you wanted to jump in?
Yeah, I did. I just I agree with you that agency protests are very beneficial in the pre-award context. The other place that I think they're beneficial is if you're the awardee and you're aware that the government's going to take some corrective action, and it gets announced at the GAO, and there is some utility in filing an agency protest to the scope of the corrective action, because you have the ability to educate the agency about what you think the corrective action should be and how you should narrow it. Like if there's a mistake in past performance, maybe you want to prevail upon the agency that, look, you don't need to let people update their price proposal. That has no relationship to past performance. It kind of give them a path to take the appropriate corrective action without putting you at risk of the award. I mean, the other benefit is, and we'll talk about this a little later, in an agency protest, other companies can't intervene. So it's basically like your own personal audience with the contracting officer to try to shape the procurement in one way or another without somebody else whispering in their ear. And I think that's a pretty good feature.
Yeah, no, that's a great point. And I think I would sort of characterize sometimes an agency level protest. You're submitting something that's you're using a legitimate process to object to something, but sometimes you can do that even if the odds of winning may be low. For example, you want to challenge the scope of corrective action. We know that corrective action decisions are subject, like everything, to the discretion of the agency, and the reviewing court or GAO is highly deferential to that decision. So you might not have any realistic chance of winning a corrective action objection, but you can still raise it to the contracting officer in an agency level protest and have the contracting officer decide it. And and even if the CO denies the protest, they've been educated, and you've now given them information, given them something to think about. So I think using an agency level protest as a means of getting information in front of the contracting officer that's outside your proposal can be really effective. So that's a great point. I mentioned that the form of an agency is less adversarial. That there's no, Paul mentioned, there's no intervener. There's also no opposing counsel. I mean, the agency internally will review, the contracting officer will review the agency level protest with their in-house agency attorney, but you're not submitting briefs, and so there's not this back and forth. It's one submission, and then the contracting officer takes about a month. The FAR says it should be, the government should use their best efforts to decide it within 35 days. Even that's not a requirement. It's aspirational. But a decision will be made, and it could be a simple deny. I know a lot of times contractors will be reluctant to file a protest. They're concerned about their reputation. They think that the agency will frown upon them if they ever file a protest, and so that's another area where sometimes contractors will opt for the agency level option because it doesn't feel like a protest as much. I mean, it can be less formal, and since it's not as adversarial, it's a way to get their objection in front of the agency without initiating protest litigation. Although this choice of form does have its benefits in a certain place, there are some pretty big downsides to it. One, I just mentioned, you have no procedural rights, and so in most cases that's actually not a good thing. You want the opportunity to file briefs. You want to obtain a record of the procurement, so you can then, through counsel, provide comments and briefing on that record. You don't have any of that in an agency level protest. It's one letter submitted, and then you wait for the decision. So you're trusting the agency entirely to conduct a fair internal assessment of the issues that you've pointed out. And as we all know, frequently, the real issues in a procurement are hidden. You're not really going to know what went wrong or where there may have been something like unequal treatment unless and until you get access to a record. So without a record and no opportunity to brief that, your opportunity for prevailing such in a post-award context are pretty small. So you got to have the right facts for this to make sense. A second major downside is that you forfeit the SECA stay, and I'll mention that next in the GAO discussion. But the SECA stay is the automatic suspension of performance in a post-award environment. You can timely file a protest at the GAO if you timely file at the agency. So you don't lose your right to go to GAO if you go to the agency first. So that's good, but that's not true with respect to the SECA stay. So if you want to stop the awardee's contract, you're wasting your time going to GAO going to the agency first, because that SECA stay is triggered based on when the protest is filed at the GAO, and it's not going to be told based on having gone to the agency first. And then a final downside, and is that there's this concept with agency level protests that in order to preserve your objection and timely take your protest concerns to the GAO, if you're not happy with the agency's determination, the clock starts ticking as soon as there is initial adverse agency action on your agency level protest. And so what that means is that sometimes you can file a protest with the agency, and before the agency has even decided it, your clock has started to go to the GAO, and you end up having to abandon anyway and go to the court, or go to the GAO. A classic example of that is in a protest where you are objecting to the terms of a solicitation, for example. If you object to an RFP and 3 days later proposals are due, but the government does not suspend the due date for proposals, that inaction is deemed to be adverse agency action on the protest, because by continuing to receive proposals, the agency is effectively telling you that they're not going to take corrective action. They're not going to address your concerns with the solicitation. So that started a clock to then go to the GAO, and that can be frustrating. I mean, we've seen a number of cases where you do file this letter to the agency, and then now you've got to monitor and make sure that have they given any hint that they're not going to sustain the protest or take corrective action. So those are just some of the downsides. But so let's move on to the GAO as a forum, right? So the vast majority of bid protests are filed at the GAO. I think over the last 5 years, I think we're in the 2,500 protests a year range. Certainly over 2,000 a year are filed at GAO, and which is significantly more, I think more than 10 times the number at the Court of Federal Claims. So the GAO is certainly the choice or the form of choice for protesters. And I mean, there's several reasons for that. I would say that the first and maybe the most obvious reason for that is the SECA stay of performance. Paul, you want to jump in?
No, well, we actually had a question that I thought was just good at this point. It's from one of our audience members, and it says, if you do an agency protest and lose and then go to GAO, recognizing no SECA stay, are you limited to the protest grounds in the agency protest, or can it be more than that, or perhaps only supplemental grounds?
I think.
Go ahead. I had my thoughts too.
So I think you're going to be limited to the grounds that you preserved at the agency, unless the new grounds are based on some new information that you learned. I mean, maybe for example, you learned something new in the agency's decision on your protest that gives you grounds. But the timeliness rules, the way the GAO treats timeliness rules, it's on an argument by argument basis. So you can be timely on some arguments and untimely on others,
Right.
like supplemental grounds. And so, you'd have to demonstrate that you did not have any, sufficient factual basis to raise those grounds with the agency.
Yeah, I mean, I think if you had 12 things you could have complained about in your agency protest, but you only complained about 6, the 6 grounds get denied, you can't resurrect all 12. I think you only protected the 6 you went after. Now, if you
Right.
learn something subsequent to that, I think you could raise that. But, if you're going to go at the agency and you want to preserve your arguments, you probably ought to go with all your best arguments, because if you pick and choose, you could be out of luck later.
Yeah, no, that's a great question. Krista, you want to jump in?
Yeah, I just wanted to add one thing. I think that this is sort of analogous to what happens with respect to filing a protest first at GAO and then a supplemental protest. I've seen a variety of cases and situations where someone knew about an issue before they got the record, and they decided to bring it up as a supplemental protest ground. You can't do that. And so it's really important that when you're assessing which arguments you'd like to make at the onset at the GAO, that you make every single argument of which you would be aware at that point in time. So I just wanted to add that quick point.
Yeah, no, that's a great point. And I think that also will speak to the desire to get a full record, and I'll mention that when we get to that in just a minute. But so let's go back to the idea of a SECA stay. So and actually, maybe before we even get there, I should just clarify for those who don't know. I mean, the Government Accountability Office, under the Comptroller General, they have authority under the Competition and Contracting Act to decide bid protests, and it's an administrative forum. Protests are decided by GAO attorneys, so they're not judges, they're not administrative law judges, but they are attorneys, they're procurement attorneys, and this is their full-time job. I mean, they understand procurement law, they understand protests, they live and breathe protests every day, and so they are very knowledgeable in this area of law. GAO was intended by Congress to be a forum that timely resolved protests, and the idea is that it would be sort of a low cost or a way for contractors to raise issues. For that reason, GAO protests have to be decided in 100 days. But one of the sort of the teeth of filing a protest at the GAO, and it's a key feature, is the SECA stay. So if you file a protest before award, pre-award protest, the government is not allowed to make the award as long as your protest is pending at the GAO. If you file a protest at the GAO after award, the government is required to issue a stop work order to the awardee during the pendency of the GAO protest. So that's what we call the SECA stay, the Competition and Contracting Act stay of performance. And it's critical because, for the most part, if you want a fair shot at having your protest grounds considered, and you want it, and if there is going to be corrective action, you want to preserve the status quo. It's not fair to allow the awardee to start, to transition, to take over a contract and start performing, and then ask the agency to fairly reevaluate proposals. At that point, if the awardee is already 3 or 4 months into performance, they're going to the odds of the agency not being influenced by that are pretty low. So, and in some cases, the contract itself, it might be too late. I mean, the nature of the procurement could either be short, could be a supply contract, or it could be some procurement where the upfront costs are so significant that once those are committed, you can't effectively unwind that. The awards, the damage is done. So the SECA stay is really, really important if you want a fair consideration of your protest and an opportunity for meaningful corrective action. You've already heard several of us mention the strict timeliness rules at the GAO, and I want to sort of clarify some of these rules for folks who have ever considered filing a protest. So The general rule at the GAO is a pre-award protest has to be filed, or any argument that's challenging the ground rules of the competition have to be filed prior to the due date for proposals. So in that case, you might know about something for 3 or 4 weeks because you have a long runway before proposals are due, and you can evaluate it, but you've got to get that in before you submit your proposal. In the post-award context, it's the 10-day rule. You have 10 days after the date of when you knew or should have known the grounds of protest, and that typically starts when the award is announced. Although generally your debriefing is going to give you the factual basis for your protest. There is a rule at GAO that if you've requested a debriefing and a debriefing is required, as they are in FAR Part 15 procurements in most cases, you are not allowed to file a protest at GAO until the debriefing's been given, and so you could have an issue of filing a premature protest. But the idea there is that the GAO doesn't want you to be filing a protest just to preserve timeliness if you still haven't received your debriefing. The expectation is that a debriefing is supposed to educate a contractor and ideally tell them the reasons why they lost and maybe help them realize that it's not worth protesting. Maybe they've learned what they needed to learn, and it's not worth pursuing. But if the basis of your protest is dependent upon information you learned in the debriefing, and that's going to be the vast majority of cases, you still have 10 days after that debriefing to file the protest. But for CICA purposes, you only have 5 days. I think a lot of people sort of constantly hear people talk about the 5-day rule, the 10-day rule. What does that mean? And so the 5-day rule is in CICA. It's in the statute that says that in order to trigger the stop work order in a post-award environment, you've got to file your protest by the later of either 10 days after the award date or 5 days after the debriefing. It's the later of those two, 10 days or 5 days. And so just to kind of give you guys an example of what that might look like. So, say for example that you have an award on day one, and then sort of typical environment, you would have the debriefing, and your award is announced on day one. You request a debriefing immediately. It's then given to you on day 6, 6 days away from the award. In that scenario, your protest to be timely at GAO is not due until day 16, 16 days after award, but 10 days after the debriefing, day 6. But in order to trigger the stay, you've got to file on day 11, which is 5 days after the debriefing. Again, because 10 days, it's either the later of 5 days after the debriefing or 10 days after award. 10 days after award is day 10, but in this case, the debriefing given on day 6 gives you that extra day to file the protest at the GAO and also and trigger the stay. Another scenario, though, and this, you don't see this as often, but it definitely comes up, and it's something to keep in mind. If on day 1 the award is made and the agency very quickly gives you the debriefing on, say, day 3, in that scenario, many people will assume incorrectly that they have to file their protest within 5 days of that day 3 debriefing, which would be day 8. But that's not true. You still have until day 10 to get your CICA stay, because that's 10 days after the award date. In that case, it's the later of the two. So sometimes you do have more than just the 5 days after the debriefing to timely file the GAO and trigger the CICA stay. Let's see. Another feature of an agency, or sorry, of a GAO protest is that the agency attorney will represent the agency. And I know Chris is going to talk about the difference of the court where Department of Justice is involved, but it's just something to keep in mind when you are litigating at the GAO. the agency itself will be represented or representing itself, the agency attorney. And so sometimes there's a sort of an agency bias, and you may not always get an independent review. That's not always true. I mean, many agency attorneys will assess their own procurement team's conduct and have no hesitation to recommend corrective action. Some agencies, though, I think where an agency attorney may have been involved in the procurement from day one. I mean, they'll be assigned to that procurement. They'll have drafted the RFP, reviewed it. They'll have reviewed the evaluation and source selection decision and related documents, and given their stamp of approval. And so when you protest, and that you're getting the same agency attorney who had already validated the evaluation and award decision. So I think sometimes in those environments, you may not always have a fresh, independent assessment of the case. That agency attorney may be more willing to defend the protest to the very end because they feel that their review and their assessment of what happened was supported. So moving on to a few other items or highlights of GAO protest, the agency report. The agency report is the main submission by the agency in response to your protest. It's due 30 days after you file the protest, and it contains the agency's legal brief. It contains the contracting officer's affidavit, a declaration stating the facts and responding to the protest. And it's just sort of most importantly, it includes the relevant record. And this is a key feature or attribute of protest of the GAO. The record that is contained in the agency report is what the procuring agency itself determines is relevant to the grounds raised. And that's very different, as Krista will mention, at the court. It means that the agency, who has a vested interest in defending the protest, gets to decide, for the most part, what they think is relevant. And so there's an obvious incentive for an agency to weed out information that may harm them or may give the protester an opportunity to develop supplemental grounds. And agencies take advantage of that. I mean, they for the most part, agencies will refrain from producing key documents. Those documents that they feel that they have to submit, that they will redact heavily, so the protester can't review and try to develop new grounds of protest. From my perspective, it's a real challenge, and one of the big downsides of the GAO. You can object to that record at the GAO, and the GAO may in some instances tell the agency, no, you got to produce more. But for the most part, the agencies are given a lot of discretion. Paul, you want to jump in?
No, I was just going to echo that James and I had a case a few years ago that we went to the GAO and lost. We won at the Court of Federal Claims, and we got the administrative record at the Court of Federal Claims. We couldn't believe some of the documents the agency had withheld as not being relevant. So we cannot underscore enough how much the agency plays games on this issue.
Yeah. And unfortunately, in protest, although we kind of call it litigation, there's no discovery. So you don't have the right to see what they're withholding. I mean, they're supposed to tell you, what information they have. But you're really sort of at the mercy of the agency, kind of giving you what they think is relevant. So that's a big downside and can frustrate a lot of protesters. For that reason, in developing grounds of protest, though, this is why you always want to target multiple aspects of the procurement. Even if you really are going in for one main reason, if you want the opportunity to make as much of the record relevant as possible, then you've got to make allegations across the various aspects of the procurement. So just something that's jurisdictionally something that's worth mentioning. There is the government, as we all know, awards task orders a significant amount of contracting actions are through the FAR Part 16 task orders against IDIQ contracts, not GSA schedule orders, but the FAR Part 16 IDIQ vehicles. And there is a jurisdictional bar for many of these task order awards. So if it's a civilian agency procurement, it has to be over $10 million in order to protest. If it's DOD, it has to be over $25 million in value in order to have jurisdiction of the GAO, unless in either of those cases, the protest is challenging an increase in the scope period or maximum value of the underlying IDIQ contract. So what that means is there's a lot of procurement actions. A $20 million Army award against a task order vehicle cannot be protested. And there's no jurisdiction in the court over task order protest. So it's a real issue, just something to keep in mind. One of the first questions you always want to assess before you go too far down the protest road. Just to wrap up some thoughts on GAO, because the GAO is such a form of choice for so many protesters, and they're issuing hundreds of decisions, written decisions every year. There's a large body of case law at the GAO. I think the GAO is consistent in their legal principles. I mean, they will follow sort of the same kind of core principles and how they interpret the FAR and apply it. I think practitioners will tell you that different GAO attorneys have different will approach a set of facts differently than others. So, I'm not suggesting that the same set of facts in every case is going to be decided the same way. But I think GAO does strive for that. I mean, their view as an organization is to try to be very consistent in the decisions. Paul?
Yeah, I just wanted to announce the CLE code is winning 2021. It's winning 2021 is the CLE code.
All right. And then finally, so recovery of fees. You do have an opportunity at the GAO to recover legal fees and costs if you are successful. And just to state the standard that the GAO uses, it's the GAO will recommend that the agency reimburse your legal fees only where the government unduly delays taking corrective action in response to a clearly meritorious protest. That's their standard. So you've got a couple elements there. The government's corrective action to the protest has to have been unduly delayed. They took too long to take corrective action, and the protest itself had to be clearly meritorious. Now, if you win the protest with a written decision from the GAO, in almost every case, that winning decision will include a recommendation for the agency to pay or reimburse fees, because the agency, you had to litigate the entire protest, and of course it was successful. So, but where this comes into play in a lot of cases is where you file your protest, and before the agency will take corrective action, before the agency submits the agency report, they will take corrective action, midway through the process. And a lot of protesters will say, hey, wait a second, our protest was successful. We want to be reimbursed our fees. We had to file not only the protest, but maybe we filed comments and supplemental grounds. And the GAO's general rule of thumb is that if the agency takes corrective action before day 30, before the submission of the agency report, that is almost always going to be considered timely. The GAO expects an agency to react to a protest, assess it, and take corrective action. So they're not going to penalize an agency by recommending they reimburse fees if they do that. But where you get into the area where fees become possible is when the agency goes past day 30 and they make you file comments or supplemental grounds, and that's where you get into that area. But just to be clear, it's always uncertain. You may not get fees on every argument that you pursue. So there's the GAO, in my view, has been pushing more and more to sort of the idea of partial recovery, and your grounds had to be clearly meritorious. I mean, close calls are not going to do it. They had to be pretty obvious. So with that, I think Krista, why don't you sort of outline your sort of highlights or discussions of protests in the Court of Federal Claims.
Thank you, James. So as those of you who know me can probably guess, I could talk about the court's jurisdiction for probably 2 full days. So I won't do that right now. For those of you who are, familiar with some of the filing processes at the court, oftentimes it's thought of as the forum to have this second bite at a protest. Well, that's certainly true for the most part. I think that there are also some serial Court of Federal Claims protesters, which I noticed a lot while I was clerking there. And so I think sometimes people just prefer the court, other times they don't, but I definitely think that this is an opportunity. If you win, or even if, sometimes someone else files another protest and you're not happy with whatever happened at the GAO, you can in turn go to the court since it is actually a court and the GAO is not. And so one of the other things that's one of the key reasons why I think some people go to the court versus the GAO, and sometimes people go to the GAO first, kind of get an assessment of what the claims are. And speaking to sort of the next step of what someone asked earlier, if you don't have to plead everything at the GAO first in order to file it at the court. So you basically start with a fresh slate and you're allowed to kind of plead what you would or would not like to when you get to the court. And so one of the best things is that you get the full administrative record. So you get every single agency evaluation document. You really get to have the full picture. And that's pretty important because while there's a jurisdictional requirement that you have a minimum of a $10,000 requirement of what you're protesting, so the award must be at least $10,000, the well-pleaded complaint requirement is pretty low, I would say. And so sort of what I talked about earlier with respect to the prejudice and standing considerations, it's sort of along those same lines, but the allegations in the complaint for standing purposes are construed as being true. And so you're usually able to get past that. And then what happens immediately after that, the parties kind of like confer and figure out what's going to happen here. And I'll get into some of the specifics of that as I kind of walk through this, but it's really important to recognize that the ability to get into the court in the first instance is oftentimes much lower, and then you will in fact get the full record. So I think it's a good opportunity if you know you have maybe one protest ground, you really think that there's going to be more. If it didn't really work out at GAO, or you just want from the get-go to get the entire record because you think it might be, the agency's evaluation might have a lot of problems, it might be strategically better to go to the court in the first instance, as you will get the full record. And so there is a 6-year statute of limitations at the court. I find this a little bit curious, given how government procurement works. Obviously, you're not going to come 5 years later and file a protest of an award that might already be done, probably is already done. And so you would obviously have jurisdictional issues on that front, but there is in fact this 6-year statute of limitations. So you don't have those strict filing requirements that you would have at the GAO in order to get to trigger the CICA stay, or to actually file at GAO in the first place. That said, at the court, you do not get that CICA stay. And so you have to, in your complaint, include a request for preliminary injunctive relief. That's in the form of an application for a temporary restraining order or a motion for preliminary injunction. And so when you include that in your complaint, oftentimes what will happen is that the DOJ attorney will work with the agency and with protester counsel. Sometimes they'll involve intervener in that process. And they'll see if they can negotiate an agreed upon stay. That happens pretty frequently, I would say. There are still instances where the parties will have to litigate that preliminary injunction process at the onset to determine whether or not there will be a stay. Candidly, I really don't think that you have a high likelihood of success. So it's much better to really try to get that agreed upon stay with the agency. And like I said, I feel like I saw that a lot at the court and now as protest counsel before I clerked and now at Venable. I think that it's much better to get that agreed upon stay rather than go through that process, but you never know it. You can have it granted. And so other things that I wanted to kind of flag with respect to this in terms of going through the motion process for an application for TRO or motion for PI is just one thing you might want to consider is, are you the incumbent? Do you have an option year on your existing contract that could be exercised? Sort of like what considerations happen here if, for example, the stay is awarded or executed. So sort of looking at it from whether or not you're the incumbent or not, I think is pretty critical, especially, and I wrote an article about this with one of the other partners in our group. Whether or not the agency will award a bridge contract is pretty key. There's been a recent decision by the court sustaining an objection to a bridge contract award because the agency has to document the reasons as to why it's having to do that. Agencies have also come out and said, I know the Department of Defense has issued an opinion on this, not so formally, but some of its some of its different employees have, basically saying, bridge contracts are not great for us. We need to stop doing this. It requires so many resources, time, money on behalf of the agency, and the agency ends up spending a lot more money when that happens. And so these are sort of some things to keep in mind when selecting the forum. And then also thinking about going through this motions process and whether or not you're able to get that stay. And so one of, I think, the most interesting benefits of going to the court is that you have the opportunity for oral argument. You don't have that at the GAO. And so this is, of course, a more formal process. I think there's often the assumption that people think, oh, the judge has already made up his or her mind before we're even getting to this oral argument. It's like, that's actually not true from what I've seen. I think that sometimes oral arguments actually can flip everything because the judge is going to have questions that he or she wants to ask. And so I think it really is an opportunity for counsel to shine and point to some of the key facts, especially if you're able to show an objective protest ground that demonstrates that something was fundamentally flawed and it did in fact prejudice you. So having this opportunity for oral argument, you can use demonstratives, you get to go into the court, you get to interact with the judge, the clerk gets to observe everything that's happening. I think demonstratives during oral argument are extremely effective. And I think it's really helpful to the court to be able to look at those and sort of contextualize some of the arguments and really pull out the issues that you think that the judge should focus on. So I think that's a really, really big benefit. Of course, too, as James mentioned, DOJ does defend the agency. I think it's really interesting to see because, of course, DOJ counsel works with agency counsel to kind of go through this process. I mean, these are like routine expertise litigators, too, who deal with these things. And so for bid protests, we deal with attorneys in the National Courts Division of the Department of Justice. And I think it's interesting to see some of the expertise. I have noticed that on higher dollar value procurements, they tend to pick some of the more senior DOJ attorneys. And Paul will talk about intervention, but I think in some of those instances, that's certainly a reason if the protest is at the court to intervene. Some of the lower dollar value ones, sometimes, you know, it'll have some of the newer attorneys. I mean, they're all great, but I think it is something to consider, you know, if you're going to come up against a 20-year tenured DOJ attorney, you might want to intervene at that point if you are the awardee. So James talked a little bit about sort of the FAFSA bar, and this is such an interesting area to me. A protest is not authorized at the court if it's in connection with the issuance or proposed issuance of a task or delivery order, except for a protest on the ground that the order increases the scope, period, or maximum value of the contract under which the order is issued. So as a baseline, typically you cannot file a task order protest at the court. That said, you can actually file GSA Federal Supply Schedule task order awards at the court. And I think that the court doesn't have as big of a body of case law on that, I think for a variety of reasons. Sometimes those awards are just lower dollar value. It's faster to just go to GAO. But I think there has been an uptick at the court with hearing these types of protests. And the court has also issued a decision sort of explaining and interpreting this, and the Federal Circuit has as well. But essentially, it has found that, you know, where an agency has so inextricably intertwined an IDIQ award with a task order award, the court has found that it has jurisdiction. And so I think that's pretty important to think about. And it's interesting to see how agencies handle their procurements in that respect. And that could be a pre-award protest argument that you'd raise. But I do think that those are kind of important things to think about. So one other thing that I think is important, and not all of the judges at the court do this, but oftentimes whenever a protest is assigned to a judge, if they're objecting to the same procurement, the same judge will get to hear all of those cases, right? So they'll get all of the different cases. And oftentimes what happens, but not always, the judge will consolidate those cases. And what that means is that the judge will listen to them and hear them all at once. So all of the filings concurrently happen, the oral argument, things like that. And at the court, the judge kind of comes up with the schedule with the parties as to what they want. It's not as rigid sort of as GAO in that respect. But I think that's something important to think about. You know, who else is a counsel that's going to be there? Another thing to think about, and I've seen this happen, is that the second you have one contractor, say everyone files a GAO, say there's 4 people file a GAO, and then 30 days, 60 days, 80 days later, someone decides to file at the court, well, the GAO no longer has jurisdiction, actually has to kick it to the court, and so everything will then go there. And I think that's something to be mindful of maybe if you're talking to, you know, as a contractor, some of the other people who competed for the work and you know that they're protesting, to kind of touch base with them and sort of see what's happening with that, because truly the second someone files with the court, it's gone from the GAO. You could be getting your decision in 2 days and it could be kicked. And I have literally seen that happen. And so I think it's really important to kind of have those conversations with other contractors if you know that they're protesting. And so one other thing is just, to get an injunction, there's of course the preliminary injunction and then there's the permanent injunction. At the end of last year, the court actually enjoined the cancellation of a solicitation of the contract award and the cancellation of the contract award. But that was really interesting. In order to get, of course, the permanent injunction, which you would get at the end of the court deciding the merits, is, one, you have to succeed. Two, you have to figure out, whether the plaintiff will suffer irreparable harm. Three, you have to look at the balance of hardships. And then four, whether an injunction is in the public interest. And Paul and I are actually talking about this earlier. It's always kind of curious if you have a protest that involves national security considerations. The agency will have a lot of discretion and the court will afford the agency a lot of deference in that respect, including when it comes to a permanent injunction. So that's just something to be mindful, is to sort of think about the type of work that's being performed in the procurement that you're protesting, because at the end of the day, that can be a really critical distinction in how the ultimate decision comes out. So one other thing, and James sort of talked about this in the context of GAO, is that in some respects, I think the court sometimes has a smaller body of case law. In other respects, I don't think that it necessarily does. I think it's constantly growing, of course, as time works. But I think that it's interesting because there are many situations in which you have the opportunity to present an issue that maybe the court hasn't exactly dealt with before. So that's sort of a unique opportunity as compared to filing at the GAO. And Paul, we'll kind of talk about this a little bit more in the pre-award context. But there's also, the court has a different standard than GAO for certain issues, including in pre-award protests. And so that's another thing to be just generally mindful of. And of course, that's the attorney's job to be sort of aware of that. But there are sometimes slightly differing standards, but for the most part, I would say they're the same. In terms of the judges, as many of you might be aware, so the chief judge is now Judge Kaplan. And so the judges at the court have 15-year terms. They're appointed by the president and confirmed by the Senate. Right now, there are actually 13 judges who are not senior status. So typically there will be 16 for the court to have like a full amount of judges. 10 of those judges are Trump appointees who joined the court over the past 2 or so years. I think that really presents the opportunity to help these new judges develop their precedent. I think it also provides you the opportunity to really frame a lot of these issues. If, for example, maybe the judge hasn't seen a federal supply schedule contract before, or a specific issue, contractor teaming agreements can be different, whether it's a federal supply schedule contract or it's not. And so given the fact that the court, can hear that, I think it's important sometimes to frame those issues for the judge. Also, I want to kind of point out that there are right now 12 senior judges. So the court does have a lot of judges right now. They do serve at the pleasure of the chief judge. And so anytime there's a change in administration, that's sort of something to think about with respect to what's kind of going to happen with the judges. But again, it's interesting because, of course, it's sort of a lottery as to who you're going to get. But I do think it's interesting, especially given that there are so many new judges, and they tend to be sustaining decisions, I think, at a slightly higher rate than maybe some of the judges that have been there longer have. I mean, I wouldn't say that as a blanket statement, but I have noticed that a little bit. And one of the other things is that the perception that the review is a little bit more focused. So this, of course, is a more formal case process. The judge has 2 to 3 law clerks, and so you have multiple sets of eyes looking at these issues. Of course, every judge operates differently, but I think that it's a little bit different than the GAO in that respect, because you really have a different, more formally structured system in place. And as I was mentioning before, there can be a slower timeline. There's no set or statutory schedule for the motions for judgment on the administrative record. So another thing is kind of like whether there's a stay that's agreed upon, whether or not you have to go through that motions process for a preliminary injunction, circumstances of the case, that sort of thing. And one thing I do really want to point out is that here throughout the process, and I think sometimes this is almost like in the back of people's mind and not at the forefront when maybe it should be a little bit more, is that the court has an obligation to make a decision on the record, right? And so the court has the full record. And so at the end of the day, the court is going to be checking every single thing that's in there. And in terms of like a stylistic sense, and this might be a little bit more for attorneys, but also I think it's important for clients to be a little bit mindful of this, especially as oftentimes you get redacted versions of the different filings. It was always a little striking to me, and I find it a bit curious when people make arguments saying, oh, it was clearly this way, or it was obviously like so flawed on that. well, if it was so obvious, I don't know that you would necessarily be at the court. So kind of avoiding hyperbole is, I think, better, and judges perceive the arguments a little bit better. And again, sort of as I was alluding to, the court will check your case law. I have literally seen instances, like both when I was at the court and as counsel for contractors, where people use ellipses and they delete the negating word, or they delete part of the information, whether it's from the record or a case that completely changes the context. The court is checking absolutely everything like that. So, to think that you can kind of might be able to slip something through, that's not so great. This is also another reason to intervene in a protest, to make sure that none of that really happens. But I think it's important to really flag, like, that will be looked at, especially because the staffing that the court has, the fact that this is a more formal process. So really make sure that the facts and things like that are correct. The last thing, I'll kind of go through this quickly, is just recovery of fees. You have to win on the merits to get that. You can get bid, preparation, proposal costs. There's 3 different requirements that you can get, that you have to meet in order to get that. But the agency, of course, has to have committed an error. It caused you to unnecessarily incur bid, preparation, proposal costs, and the costs have to be both reasonable and allocable, so specifically incurred for that contract. So I think that's sort of just an important thing to keep in mind as well if you're hoping to get that. And I will now turn this over to James to talk about 2 of the last forums.
Yeah, thanks, Kristen. I think in the interest of time, we'll probably jump right over to intervention with Paul, but I was just going to mention that there are, if you do find you're in a situation where your task order protest is barred by jurisdiction, there is an opportunity to file what's called a task order ombudsman complaint. It's not a protest, but it can provide you some relief. And then finally, something else to keep in mind, if you are in an FAA procurement, there's a separate forum, the Office of Dispute Resolution for Acquisition, ODRA, for FAA procurement. So don't go to the GAO if you've got an FAA procurement. So with that, Paul, why don't you talk about intervention?
Yeah, I will make one comment about the task order ombudsman. I haven't found it worthwhile at all. I've submitted those and never heard anything back. The other thing about ODRA that's worth mentioning is it's very difficult there to get a stay, unlike at the GAO. But let's go ahead and turn up to intervention. If we could go to the next slide. Just as a general matter, typically, a party can't intervene in an agency level protest. Intervention is available with the GAO, COFC, and ODRA protests. Certainly, it's always available in a post-award protest if you're the awardee. Sometimes it'll be available in the pre-award protest. I've had cases where the GAO has let a party intervene. I have cases where they haven't, and the court can let people join permissively as well. So why intervene? Why spend the money? If we go to the next slide. One of the things that's really important to remember is that when you file a protest at the court or the GAO, it's going to be subject to a protective order. So in many cases, you as a company representative are going to have little insight into the proceedings other than seeing redacted documents. So what would the benefits be to intervening? A lot of times the agency counsel just need help. And depending on the agency, depending on the individual, they will give you, your outside counsel, a lot of latitude in what they can do. Motions to dismiss, research, drafting portions of various documents. The other thing that outside counsel can help with is sort of bucking up the agency on the award decision so they don't prematurely or incorrectly take corrective action. We work real hard to limit the scope of the record because typically the supplemental protest grounds are stronger than the initial ones. We're also able to make arguments that maybe the government is not comfortable making, so we can also augment the government's filing. At a minimum, an intervention is going to give you the ability, or your company the ability to protect confidential information under the protective order, because there's a redaction process that I'm sure many of you are familiar with, and typically the the awardee or whose award you're protesting is going to try to redact as much as they can, or they're going to try to expose as much of your information as they can. So it's helpful to have somebody to support. I think the key to a successful intervention is really working hand in hand with your outside counsel to determine how active you want to be. So, you could do an intervention where you just want your outside counsel to monitor and report. You could have an agreement with your outside counsel where they could come to you and ask for permission to do work, or, for example, like file a motion to dismiss or to help the government. But you can really manage your cost in the intervention process by working hand in hand with the but working hand in hand with the agency. Real quick on the next slide, if we could. One of the other benefits is doing a request for dismissal. I mean, as a general matter, unless I could kick the entire case to the Court of Federal Claims, I don't think I'd advise a client to file a request for dismissal. But at the GAO, as we've talked about, it's imperative that you do work with the agency to get a request for dismissal in on some grounds, because it's going to limit the agency report and limit the potential for supplemental arguments. So with that, why don't we go to successful arguments and themes? So each year the GAO issues a report that talks about the most common issues for sustaining protests. And since 2015, the grounds have been unreasonable cost or price evaluation, unreasonable past performance evaluation, failure to follow the stated evaluation criteria, inadequate documentation of the record, unreasonable technical evaluation, a flawed selection decision, and unequal treatment. And with that, Krista will quickly cover developing the grounds of protest.
Yes, so thank you, Paul. This is sort of a recap, but basically anything that you can glean from the debriefing or a Q&A, that's very, very helpful to develop the grounds of protest. And it really helps the attorneys that are working on the protest to discern sort of what strengths and weaknesses that you might have with respect to your overall litigation strategy. And so I think from a very high level, there's, the protester versus intervener, GAO versus court, objective versus subjective grounds to kind of keep in mind as we sort of talk through this. But one of the things that I think is the most helpful, and this can be done at both the court and at the GAO, is before being admitted to the protective order. At the court, you'd get the redacted complaint. At the GAO, you get the redacted protest. So it's really helpful to have a call with a client to kind of walk through what their impression is based on what has been redacted. So before we're admitted to the protective order, we're able to discuss those things and opine on what the protester might be alleging. If, for example, you're intervener, I think that's really helpful. Of course, if you're the protester, we can kind of walk through and say, what do you think seems weird? What have you found online? And we kind of talked about a little bit of that. Of course, at the GAO too, there's, the initial versus supplemental phases. It's helpful to have that, especially at the beginning, to have a general understanding. But a lot of what we do is built on kind of what the client provides. And so at the court too, I want to just flag that the full record's not produced until you get to the motions phase. So you get that before, and then you have I would say like maybe 2 to 3 weeks, depending on how quickly it's going, to kind of go through and file the motions. Again, you get the full record. And we'll get into some of the objective versus subjective protest grounds. But, at the GAO, you really want to cast a wide net to try to get as much of the record you can, because the agency is going to limit the record to the extent that they're able to. The court can't do that. And so, by virtue of the court producing the full record, there really are very different litigation strategies. And I think it's kind of just helpful to keep that in mind as you try to develop, if you want to protest. But your grounds, of course, at the end of the day, they can't be so speculative that you're just throwing things out of left field and hoping that you're going to get some piece of the record. And so some of the things, just as an attorney, that, I think are some of the more important documents that I'll look at, of course, are the solicitation. That's one of the first things that I start with when I look at a protest. And then, of course, when you have the record, the award decision document is basically so key to see, especially if it's a best value procurement, sort of how the trade-off was conducted. The Q&A and the debrief, there are so many times I will go to the Q&A and say, what did they say? Did they discuss this? Is this an untimely ground now that we're dealing with? I think that's really important to kind of look at that. Like, should you have known? And in the context of pre-award protest too, I think a really good test is sort of like, would you have so substantially changed your quote based on what was included in the solicitation? If the answer is yes, you should probably file a pre-award protest, whether it's the agency, GAO, or the court. But again, those Q&A and the debrief, documents are so critical. Those are what we often look at. We will scan the record. And another thing too is just to be mindful of the glass house, and we're checking that as attorneys. I mean, I know that I routinely check that. If we make this argument, is this going to be a problem later? Is this a problem with the client's proposal, right? And so if you think that there might be problems with your proposal that you're suggesting we argue are a problem with the awardees, that's a very careful balancing game. And I think it's something to really think about, like the framing and whether or not you even want to bring that up. And so one of the things that I kind of want to talk about too, so that we can get to the actual substantive aspect of this, is just the motions to dismiss, especially at the court level. You have oftentimes, lack of subject matter jurisdiction or failure to state a claim upon which relief can be granted. But I think one of the interesting ways to kick something as intervener, or try to at least, and there's a very small body of case law on this, is if you're able to show that the protester, so you would be the intervener here, because the DOJ is not going to make these arguments sometimes, right? They're not going to say the agency messed up its evaluation. It's to say basically the protester is alleging, all these things. That's fine and dandy. However, they don't have standing because their proposal is actually non-compliant. The GAO has been sustaining this, and the court has sustained this. And so you always want to be kind of cognizant of that and attack that if you're an intervener. And I think that can be so worthwhile at the court, because the court doesn't have to breach the merits at that point if they do in fact determine this person's proposal was not compliant. And so the motions to dismiss process is combined with the cross motions for judgment on the administrative record. The court can go through that entire process and still kick the entire case at the end based on a lack of standing if that protester's proposal is non-compliant. So those are some of the quick things we want to hit. And now we will get into more of the substantive grounds.
So for pre-award protests, I mean, there are just a handful of themes that you have. I mean, typically you would bring it if the terms are unduly restrictive, that you have a situation where they've written the terms in such a way that only your competitor can bid for the procurement. If there's a patent ambiguity or conflicting provisions in the solicitation, so you don't really know what the agency wants. A failure to include a clause that's required in the solicitation, or frequently where the government includes clauses that should have been excluded. I mean, that would be another good area to address. And then certainly if there's a flawed evaluation methodology. On the next slide, we have a few others that you should consider in the pre-award context. It deals with small business concerns, exclusion from the competitive range. The one caution I would have is that if you are excluded from the competitive range, ask for your debriefing and make the government tell you they're going to defer it. If you agree to defer the debriefing until the end of the competition, you're not going to get your stay. So, but if the government defers the debriefing, you can still be eligible for a stay. So you want to force the government to do that. And then last minute amendments to the solicitation, and you can also have issues related to organizational conflicts of interest. At the GAO, a protester generally doesn't have to protest an OCI prior to a contract award, but there are some limited circumstances where you do. At the Court of Federal Claims, things get a little bit trickier. The court doesn't necessarily default until after award for a OCI issue. So you really need to look at those very closely to getting the time down for that. And with that, I'll turn it over to James on post-award protests.
All right, thanks, Paul and Krista. And I think just to wrap up today's discussion, I think we'll end with just a brief overview of considerations as you're thinking about what type of post-award grounds you may have. I would say at a very top level, the way that I like to break down those grounds that are more likely to be successful are the objective type arguments versus the subjective ones. I mean, every type of protest ground is there's probably going to be one set of facts where it can be successful. But what we're really talking about here are areas where you're more likely to have success. So the classic arguments, and these are sort of the common themes, are failure to evaluate proposals according to the solicitation, according to the FAR regulation, disparate treatment, unequal treatment among offerors, an awardee missing certifications, unequal discussions. And what I mean by objective arguments, I mean, it's unequal treatments is always a good example. I mean, if your proposal, or let's say the awardee received a strength for exceeding the minimum, service levels, or SLAs it may require a certain response time 95% of the time, and if they get a strength for proposing or committing to meeting a certain response time in 98% of the time, more than the 95% required, and you also proposed 98% but didn't get a strength, I mean, that's unequal treatment. That's classic. And the reason that's such a good ground to protest is because the court, the judge or the GAO attorney deciding the case doesn't have to decide whether the issuance of a strength is appropriate or not. They just have to decide whether the two offerors were treated equally. And so any ground of protest that stays away or steers clear of getting into judgment calls of the agency are going to be ones that where you're going to find a lot more success. It's not to say those other grounds can't be successful. They certainly can, and they are in some cases, but it's just much more difficult. The subjective grounds are sort of the classic. We should have received an outstanding rating instead of a good rating. You're never going to win that argument on that basis alone. I mean, no GAO attorney or judge is ever going to say that the agency was unreasonable in finding your proposal very good, not exceptional. I mean, that's a classic subjective judgment call of the agency. You're not going to win. But these are grounds that we will often raise and that protesters will raise to get in the door. Sometimes your only basis of finding out more information about what happened is to file a protest based on these subjective grounds. And so you'll still see plenty of protests that challenge, the failure of the government to give you more strengths, the failure to give you higher ratings. Those are going to be difficult grounds, or conversely, challenging the awardees' ratings and saying that, no, there's no way this person could be, the awardee was worthy of an outstanding rating. But those subjective grounds can get you in the door and allow you to, and once you can see the proposal and you can see the full record, what we always try to do is then sort of steer those arguments to more objective type issues like unequal treatment. Krista, did you want to chime in?
Yeah, just really quickly, recognizing the time. I just wanted to note too that, at the court as well, you can make these arguments sometimes with respect to the technical or past performance evaluation. At the end of the day, I mean, the amount of deference that's given to agencies on that can be pretty high. That's not to say you won't win. There are plenty of times, especially if a proposal, of the awardee does not technically comply with the requirements of the solicitation, I think that you can win. And that sort of goes into the objective versus subjective. Did you meet the requirements of the solicitation versus, does your approach actually work? And I think it's helpful for clients to especially explain a lot of the technical aspects of things for that very reason, to try to have a higher likelihood of success on these grounds, be it past performance or technical. The work you do best. And so the more you explain to your attorneys the various factors and circumstances and, likes or dislikes of the agency in that regard, that really helps us as attorneys figure out how we want to frame those issues for the GAO, the judge, or whatever forum that you're in.
Yeah, those are great points. Thanks, Krista. I would just sort of maybe conclude with maybe a final thought on this last bullet here on unreasonable best value determination. So this is sort of a good example where you'll see a best value determination, and the difference between a good protest ground and maybe a weak protest ground. A weaker subjective argument would be one that would just challenge the government's judgment call in saying that someone with, slightly higher adjectival ratings is worth a 10% price premium. The government may say that in their debriefing. They say, they've selected that awardee, and you're saying, well, there's no way. We offered $7 or $8 million of savings, and this company, the awardee, only had a slightly higher higher rating than us, that's just objectively unfair. Well, it's going to feel unfair, but typically that's going to turn on what's really a subjective judgment call on the agency. The way that you're in some fact patterns you can prevail in those arguments, but where you can kind of steer that argument to an area where that's more likely to be successful is if you can say, the agency did not, the best value decision was inconsistent with the RFP's evaluation scheme, where the government, maybe where the RFP said that price was significantly more important than the non-price factors, and there's no evidence that the government gave significantly more weight to the price that your price savings, and instead it looks like they did the opposite. They gave a lot more weight to the slightly higher civil technical rating. That is a much better argument because now you're challenging the process, the agency's compliance with the terms of the RFP, and it doesn't require the judge or the GAO attorney to tell or ultimately to decide which proposal is the best value. It just simply requires the reviewer to say, this was inconsistent with the rules of the competition, and so we're going to sustain the protest and order the agency to go back and redo this. So I think with that kind of concludes our discussion of this portion of this 4-part series on bid protest. Paul, do you want to wrap us up?
No, yeah, I just thanks again for all the people that joined us today. I apologize, we ran a little long. We had a lot of information to cover. To the extent we didn't get to your question during the session, we'll follow up with you individually. And then if we could just go to the next slide, just to remind everybody that we have the final 2 presentations relating to bid protest issues coming up in the next 2 weeks. And I hope that all of you can join us, and I hope that everybody has a good rest of the week and a great weekend. So thank you very much for joining us today.